This is the Lex Beyond podcast by Lexicon Labs. I'm Lex.
And I'm Bianca.
What if an industry that is so big, we are talking billions of dollars changing hands, commercials completely taking over the Super Bowl, branding that is integrated into the very fabric of modern sports, what if that entire industry could actually be wiped out overnight with the stroke of a pen?
I mean, honestly, it sounds like a conspiracy theory, or maybe the plot of some financial thriller where the guy in the trench coat hands over a secret dossier. But it is a genuine legal possibility facing the sports gambling and prediction market world today.
I am your host, and joining me to unpack this massive legal collision is our resident legal and regulatory expert. And, that really is a terrifying thought if you are an investor, or even just a casual fan who likes to place a parlay on Sunday.
Before we get to that impending doom, we should probably start somewhere a little more relatable.
Yeah, I want to talk about how we make choices in life. Because human beings, we really love binary choices, don't we?
Oh, we absolutely crave them. It simplifies the world. We need that clarity to function.
Exactly. Think about it. It starts when you were a kid in school. You sit down for a test, you are sweating a little bit, tapping your pencil on the desk, you look at the paper, and it says true or false. And that is comforting. Because there is a right answer and a wrong answer. There isn't an option for true, but only on Tuesdays.
Yeah, or think about your career. You get a job offer, and you basically have two buttons in front of you, accept or reject. You don't usually get a button that says, accept, but I want to change the entire corporate structure first. It is A or B. We are completely wired for that.
Even in sports, which frankly is the backdrop for our entire conversation today, we're obsessed with binary outcomes. The referee goes under the hood, looks at the slow-motion replay from 50 different angles, zooms in on the grass pixels, and has to make a decision. Is it a catch or is it not a catch?
There is no middle ground there. You cannot sort of catch a football. It is a zero-sum determination. Did the toe drag or didn't it?
Right. And that binary mindset, option A versus option B, is typically how we look at lawsuits too. We see a plaintiff and a defendant. One party wins, the other party loses. It feels like a gladiatorial match where one side simply has to be right. We treat the Supreme Court like it is the Super Bowl.
We do, but the law is rarely that simple. And that is the trap. We often look at a legal battle and see two fighters in the ring, assuming one will be the champion. But in the world of law and high finance, litigation often evolves in a way that leaves the court with what we call a false binary.
A false binary. That sounds ominous, sort of like a glitch in the Matrix.
It is, in a way. It creates this situation where everyone is arguing over option A or option B, completely ignoring a third invisible option. And often that third option is the one that changes absolutely everything, is the option where the referee stops the game and says, actually, the field itself is illegal.
Okay, let's unpack this. Because today, we are looking at a massive war breaking out in the legal system. We have a stack of sources here that is frankly overflowing my desk. We have legal alerts from the law firm Holland & Knight detailing a chaotic month of court rulings. We have filings from the Commodity Futures Trading Commission, the CFTC. We have a transcript of a Face the Nation interview with former Governor Chris Christie, who is, well, let's just say he is not happy.
To put it mildly, he is furious.
And we have this fascinating analytical framework document called the false binary. So our mission today is to look at the explosion of prediction markets platforms like Kalshi and their outright war against state regulators.
But we aren't just looking at who wins the fight. We aren't just scorekeeping here.
No. We're going to look beyond that false binary of federal versus state to see that third invisible option you mentioned, the option that could completely wipe the board clean.
Exactly, because this is a story about jurisdiction, sure, but it is really a story about the hidden risks in a massive economy that everyone just assumes is too big to fail.
So let's get into the weeds. If you haven't been paying attention to the legal journals lately, and, I do not blame you if you haven't because they can be incredibly dry, you might have missed that February 2026 was absolute chaos.
Yeah, calling it a flurry of action is an understatement. According to the Holland & Knight alert we have, the industry effectively exploded into legal warfare this past month. It was like someone kicked a giant anthill.
Who are the ants in this scenario? Let's introduce the players here. Who is actually fighting?
Well, in one corner, you have the heavyweight champion of federal regulation, the CFTC, the Commodity Futures Trading Commission. Now, for those who don't know, these are the guys who usually regulate wheat futures, corn, oil, gold. But on February 17th, 2026, they filed a brief that essentially slammed their fist on the table. They reasserted exclusive jurisdiction over event contracts.
Event contracts, that is the fancy term for prediction markets, right?
Yeah. Correct. We will get into the specific legal definition later, but basically, these are contracts where you make money based on the outcome of a future event, like an election, or in this specific case, a sports game.
So the CFTC is saying, this is ours. Back off.
Exactly. Chairman Michael Selig was quoted in their press release saying that state enforcement is a power grab that ignores the law. He is saying, we are the experts here. These are derivatives, not bets. He is framing this as a sophisticated financial instrument, not something you do with a beer in your hand at a sports bar.
Okay, so that is the feds. Who is in the second corner?
The platforms. Companies like Kalshi, they are the ones actually offering these trades to you and me. Their argument is that they aren't bookies. They are offering federally regulated financial products. They say they are financial exchanges akin to the New York Stock Exchange, not casinos.
That distinction matters a whole lot for their stock price, I imagine.
Oh, absolutely. It is a difference between being a tech finance darling and a highly restricted gambling operator.
And in the third corner?
The states. Nevada, Tennessee, Massachusetts. They are looking at this and saying, nice try, you can put a suit and tie on it, but this is gambling, and gambling belongs to us.
And they want that tax revenue.
They absolutely want the revenue, but they also genuinely believe they have the right to police it. So you have the feds, the tech companies, and the states all wrestling for the remote control. And the scoreboard is completely confusing.
Confusing is definitely the right word. Let's look at the scorecard from this past month. It is a split decision depending entirely on where you look.
It is a total mess. Let's start down in Tennessee. This was a huge win for Kalshi. The U.S. District Court for the Middle District of Tennessee granted a preliminary injunction in favor of the platform.
Okay, walk me through the logic there, because if I am a judge in Tennessee and I see someone putting money on the Titans to win, that looks like a bet to me. How did they decide it wasn't?
The court took a very literal reading of the federal law. They said that these contracts are likely swaps. That is a specific type of financial derivative. And because they are swaps regulated by the CFTC, the court said federal law preempts state law. Basically, Tennessee cannot regulate them because the feds already do.
That seems like a massive loophole. You just change the label on the box from bet to swap, and suddenly the state police cannot touch you.
That is exactly what the state regulators are screaming about right now. The judge even reasoned that a Titans game is an event, and betting on them to win is betting on the occurrence of that event. Therefore, it fits the legal definition of a swap.
Wow. Okay, so score one for the prediction markets. But then you go out west to Nevada.
And it is a completely different story. Nevada is the heartland of gambling. They do not take kindly to interlopers. The Ninth Circuit Court of Appeals denied Kalshi's request for a stay.
Which means what, practically speaking?
It means Nevada was free to go on the attack. The Nevada Gaming Control Board filed for enforcement immediately. They want to shut the whole thing down. And here is where the legal maneuvering gets really interesting. Kalshi is trying desperately to move that case to federal court.
Why? Why does the venue matter so much in this situation?
It is all about the home court advantage. If you are fighting a gambling case in a Nevada state court, the judges are steeped in Nevada gaming law. They see absolutely everything through the lens of casino regulation. You are probably going to lose. You want a federal judge who cares more about federal preemption and the abstract power of the CFTC than protecting the Las Vegas Strip.
That makes sense. It is like trying to get your trial moved out of a town where everyone already hates you.
Exactly.
And then there's Massachusetts.
Massachusetts is somewhere in the middle. The appeals court there stayed an injunction. It essentially allows Kalshi to keep operating for now, but they didn't rule on the actual merits of the case. They just pressed pause.
So the takeaway for you listening from this chaotic landscape is that it is a total mess. We have 40-plus cases, the exact same set of facts, people trading on sports outcomes, but different courts are giving completely different answers.
It is a highly fractured landscape, and that fracture is exactly what forces this issue to the next level. But before we get there, we have to understand why everyone is fighting the wrong battle.
Which brings us back to that concept of the false binary. We talked about it at the top, the trap.
Right. If you look at those cases, Tennessee, Nevada, Massachusetts, the question seems to be who gets to regulate this. Is it mom, the states, or is it dad, the federal government?
That feels like the logical question to ask. Someone has to be in charge. It is like when you were a kid and you want to know who to ask for permission to go to the ice cream shop.
But notice the massive assumption baked into that question. Both sides are assuming that the kid, which in this analogy is sports gambling, is definitely going to the ice cream shop. They assume the activity itself is legal and here to stay, and the only debate is over who collects the allowance money.
The tax revenue or the federal fees.
Right. They are fighting over custody of incredibly lucrative industry.
But our source material suggests there is a third option.
The uncomfortable truth. What if the doctor said, no sugar?
Meaning, what if the law actually says no? Entirely.
Exactly. We have to remember that Congress passed laws decades ago that essentially said no to sports gambling on a national level. The Wire Act is the big one, which we will discuss later. But the point of the false binary document is that by arguing over federal versus state, we are ignoring the possibility that the answer isn't federal or state, but neither.
That is a heavy concept. Because if the answer is neither, then Kalshi loses, but the states lose too. Everyone goes home empty-handed.
And that brings up a really important point about how our system is supposed to work, which the source document highlights perfectly.
Yeah, this part really stuck out to me. It said, democracy is obeying laws even when they are inconvenient or outdated, until they are actually changed by Congress, not just ignored by tech companies.
That is the crux of the entire issue. We have this Silicon Valley mindset of move fast and break things. If the law is old, just ignore it and build the app anyway. But in a democracy, if a law is old, you lobby Congress to change it. You do not just pretend it doesn't exist. The false binary exists because we have collectively decided to ignore the doctor's orders because we really, really want that ice cream.
But hold on. I can hear you at home. And frankly, the investors yelling at their speakers right now.
Yeah.
They are saying, come on, the genie is out of the bottle.
That is the too big to fail argument.
Right. Is it simply too late to shut this down? I mean, look at the scale we are talking about. We are seeing venture capital money pouring in by the billions, massive advertising campaigns, consumer adoption is through the roof. People love this stuff. It feels like Uber in the early days, where they just showed up and said, we are here, deal with it.
It feels permanent. That is what lawyers call legal realism. The idea that courts will not destroy a massive functioning economy. But let's bring in a voice who thinks it is all smoke and mirrors. We have that transcript from Face the Nation with Chris Christie.
The former governor of New Jersey.
Yeah.
And let's not forget his background here. He was the guy who fought for years to get sports betting legalized at the state level. He went all the way to the Supreme Court to strike down the federal ban so New Jersey could have sports books.
Which makes his perspective here absolutely fascinating. He is not anti-gambling. He is essentially the godfather of legalized sports gambling in America.
Yet in this interview, he seemed, well, pissed.
He was visibly frustrated. He spent millions on legal fees, went through the front door, got the Supreme Court to rule in his favor, and painstakingly set up a state-by-state regulatory framework.
And now he sees these prediction markets just bypassing all of that.
Right. He had some choice words for them. He said, if it quacks like a duck and walks like a duck, it's a duck.
The classic duck test.
His argument is brutally simple. You can call it an event contract, you can call it a derivative, you can call it a swap. But if you are putting money on the Kansas City Chiefs to win the Super Bowl, you are betting.
He called them road cowboys.
He did. He said they are flouting the laws that states spent years setting up. And his biggest concern, at least the one he voiced most loudly on the broadcast, was integrity.
The integrity of the game.
Right. He pointed out that 40 states have set up robust regulatory schemes. They have rules to protect consumers. They have rules to stop marketing to teenagers. They have advanced systems to track insider betting.
Insider betting. How does that work in sports?
Imagine if a team trainer knows the star quarterback has a flu that hasn't been reported to the press yet. State regulators have sophisticated systems to watch for weird betting patterns that might indicate that information leaked. Christie's argument is that prediction markets are completely bypassing all of that surveillance. They are saying, we don't care about your laws because we aren't bets.
And Christie is saying that is incredibly dangerous.
He is. And he drew a really interesting contrast regarding the NFL itself during that interview.
Oh, yeah. He mentioned Jeff Miller, the NFL executive, calling prediction markets innovative.
Which sounds like a ringing endorsement from the league. But Christie contrasted that with Roger Goodell, the commissioner. Goodell has remained very cautious about all this. He talks constantly about brand protection.
It is almost like the business side of the NFL sees the massive pile of money, but the governance side sees the existential risk to the sport.
Exactly. But let's go back to the too big to fail idea. Christie thinks the states should win this fight. The platforms think the feds should win. But does the Supreme Court actually care how much money is involved?
That is the billion-dollar question. Does SCOTUS care about VC investments and Super Bowl commercials?
Historically, no. They are justices for life. They do not have to run for re-election. They do not care about quarterly earnings reports or tech valuations.
They care about the text.
They care about what the statute actually says. If the law says the activity is illegal, the sunk costs of the industry do not change the law. If you build a beautiful, expensive skyscraper on land you do not own, the court doesn't say, well, it's a really nice building, so you can keep it. They say, tear it down.
So the genie's out of the bottle argument might work on politicians, but it doesn't necessarily work on Supreme Court justices.
Precisely. And that brings us to the tool we need to use to understand how the Supreme Court is going to actually look at this. Because they aren't going to look at just one lawsuit in Tennessee. They are going to look at the whole picture.
We need a new framework. In the outline provided in our sources, this is called the lexicon lens.
The lexicon lens. This is the absolute key takeaway for you today.
Define it for us. What exactly is the lexicon lens?
The lexicon lens is the robust, holistic, multidisciplinary approach adopted by Lexicon Labs. The mistake most analysts make is looking at one single statute in a vacuum. They look at the Commodity Exchange Act and they stop there. Or they look at state gaming laws and stop there. The lexicon lens says you cannot solve this unless you look at the complicated web of statutes all at once.
Because they interact with each other. They bleed into each other.
They collide with each other, and we have to assert right now this issue is guaranteed to go to the Supreme Court.
Why are you so sure about that?
Because of the circuit split we talked about earlier. Tennessee says yes, Nevada says no. When two federal appeals courts fundamentally disagree on the same federal law, the Supreme Court almost always steps in to break the tie. Plus, the sheer amount of money involved and the fundamental questions of federalism, it is absolute catnip for SCOTUS.
Okay, so when it gets there, how will they view the CFTC? We saw in the press release that Chairman Seelig is very confident. He says they have exclusive jurisdiction and decades of precedent on their side.
And, 5 years ago, he might have been right. But we have to talk about the Loper-Bright factor.
Loper-Bright. That is the recent Supreme Court case that killed Chevron deference, right?
Correct. And we really need to explain why this matters, because it changes the whole game. For 40 years, courts used Chevron deference. It basically said, if a law is ambiguous, we will trust the federal agency's interpretation of it.
So if the CFTC said, we think the phrase event contract covers a football game, the court would say, okay, you guys are the experts. We defer to you.
Exactly. The agency was basically acting like the umpire. And the courts just sat back and watched the game. But Loper-Bright killed that.
So what happens now?
It is dead. Buried. The courts will not just trust the CFTC anymore. Now, the judge is the umpire. The CFTC is just a coach yelling from the sidelines. The judge will pull out the dictionary and decide for themselves what the word swap actually means.
I have a quote here from the source notes from Justice Gorsuch in a case called Learning Resources. It's pretty scathing. He said, "Men are not angels. We disregard that insight at our peril when we allow the few to aggrandize their power."
Men are not angels. He is saying regulators are inherently power hungry. He is saying that just because an agency claims jurisdiction, it doesn't mean they actually have it.
So the CFTC walking into court and saying this is ours isn't the slam dunk it used to be.
It might even be a liability with this specific court. The Supreme Court is very skeptical of the administrative state. So applying the lexicon lens, we have to look at how SCOTUS will analyze this without just deferring to the CFTC. And that brings us to the 3P framework.
The 3 Ps. This is the heavy lifting, folks. If you want to sound smart at a dinner party about the future of sports betting, this is the framework you need to understand.
The 3 Ps are preemption, permissibility, and parallelism.
Let's start with P1, preemption. This is the jurisdiction question we have been circling.
This is the fight we are seeing in the news right now. The conflict is between the Commodity Exchange Act, the CEA, and state gaming laws.
The CEA gives the CFTC exclusive jurisdiction over transactions involving swaps.
Right. And here is the logical argument chain the platforms use. 1, a swap is defined as an agreement based on the occurrence or extent of an occurrence of an event.
Okay.
2, a sports score is an event. 3, therefore, betting on a sports score is a swap. And 4, therefore, the CFTC owns it and states cannot touch it.
That is the Kalshi argument in a nutshell.
That is the exact argument that won in Tennessee.
But the states have a counter-argument.
They certainly do.
The states have a shield, the 10th Amendment.
The States' Rights Amendment.
Right. The 10th Amendment says that any power not given to the feds is reserved for the states. The states argued that the Constitution never gave Congress the power to regulate gambling or morals. Therefore, that power belongs to the states. So if the CFTC tries to preempt state gambling laws, they are overstepping their constitutional bounds.
This is the 10th Amendment versus the Supremacy Clause. It's a clash of titans.
It is. And honestly, this is where 90% of the lawyers and the press are focused right now. It's the sexy constitutional fight. But in my opinion, it is the shallowest part of the argument.
Because it assumes the activity is legal in the first place.
But let's play devil's advocate for a second. Let's say Kalshi wins P1. Let's say SCOTUS agrees that these are swaps and the feds have jurisdiction. That leads us directly to P2 permissibility.
This is where the false binary completely breaks down. Just because the CFTC can regulate it doesn't mean the contract is actually legal.
Wait, explain that. If the CFTC regulates it, isn't it legal by definition? If mom says I can have the cookie, I can have the cookie, right?
Not necessarily. The CFTC has the power to ban contracts that are contrary to public interest. And historically, sports betting has been considered heavily contrary to public interest.
But the current CFTC seems okay with it. They're fighting for it.
For now, yes. But that is a political decision. A new administration could change that overnight. But more importantly, we have to talk about the sleeper agent hidden in the statutes.
The Wire Act.
The Wire Act. Passed in 1961, it was designed by Bobby Kennedy to go after mobsters who were using telephones to run numbers games across state lines.
Right.
It strictly bans the interstate transmission of bets or wagers.
But Kalshi says, we aren't bets, we are swaps.
And here's where the court might use the duck test, or more formally in legal terms, the economic substance doctrine. Labels do not save you in federal court.
Has this been tested before? Have people tried to use different labels to avoid the Wire Act?
It has. Look at the history. Look at Jay Cohen.
Who is Jay Cohen?
Jay Cohen was an internet pioneer in the late 90s. He ran a site called World Sports Exchange. He operated out of Antigua to avoid U.S. laws. He argued that because he was offshore, and crucially, because he structured his products as sports futures, he wasn't violating the Wire Act. He actually came back to the U.S. to fight the charges in court because he truly believed he was innocent based on those definitions.
What happened to him?
He went to federal prison. The court didn't care what he called them. They looked at the substance of the transaction. You put money up, you get paid if a team wins. That is a bet.
Wow. So even if Kalshi wins on preemption and the court says, sure, it's a swap, the court could look at P2 permissibility and say, okay, it's a swap, but it is also a bet under the Wire Act. And since you are transmitting it across state lines over the internet, it is a federal crime.
Boom. That is the doctor says no sugar outcome, federal jurisdiction, but the underlying activity is entirely illegal.
That is the ultimate nightmare scenario for the industry. Billions of dollars just up in smoke. But there is one more P. P3 parallelism. I think this is the most fascinating one of all.
It's the coexistence question. This is the one that really keeps state regulators up at night. And frankly, it should keep the executives at DraftKings and FanDuel up at night, too.
The what-if scenario. Suppose SCOTUS rules that these are swaps and they are legal. Federal law wins. What happens to the state-regulated sportsbooks?
Well, let's look at federal law. There is generally a strict ban on trading swaps off exchange. You have to trade swaps on a regulated exchange like Kalshi.
Okay, I am following.
So if DraftKings is offering the exact same product betting on the Chiefs to win, but they are calling it a bet, not a swap, and the Supreme Court has just ruled that betting on the Chiefs is, legally speaking, a swap.
Oh, wow. Then DraftKings might accidentally be running an illegal off-exchange swap execution facility?
The nuclear outcome. If prediction markets are the only legal federal way to do this, the state-regulated systems might technically become illegal bucket shops.
Bucket shops. That is an old term. It sounds like something straight out of The Great Gatsby.
It goes back to the early 1900s. A bucket shop was a shady place where you could go and bet on the price of a stock, but you weren't actually buying the stock on the New York Stock Exchange. The shop just bucketed your order. It was pure gambling on stock prices.
And Congress hated them.
Despised them. They viewed them as parasitic gambling dens that manipulated markets. So federal law completely banned them. If you want to trade on the price of something, you have to do it on a real regulated exchange.
So connect the dots for us here. If SCOTUS says sports betting is actually financial trading,
then DraftKings is a bucket shop
Oh.
because they are letting you bet on the price of an event without being a federal exchange.
that would mean the entire state-regulated industry is illegal.
Exactly.
But prediction markets are playing nice right now, aren't they? They aren't actively suing DraftKings.
Not yet. Right now, they need allies. They need to look like they are just another option for the consumer. But imagine they win on preemption. Imagine they get that Supreme Court ruling that says this is exclusive federal jurisdiction.
Why wouldn't they sue to shut down their competitors?
Exactly. It is a winner-take-all market. If you are Kalshi and you have the Supreme Court ruling in your pocket, you turn around and sue DraftKings under the Commodity Exchange Act and say, shut them down. They are an illegal bucket shop eating into our federally protected market.
So P3, parallelism, essentially asks, can these two systems coexist? Or does one inevitably kill the other?
The lexicon lens suggests that parallelism is very, very difficult to maintain under the current statutes. The definitions are just too contradictory. You cannot have the exact same activity be a swap federally and a bet locally without something breaking.
This is bleak or exciting, depending on your perspective. If you are a lawyer, this is the Super Bowl.
It is absolutely the Super Bowl of regulatory law.
But we are missing someone at the table here. We have talked about the regulators, the states, the platforms. But Section 6 of our discussion brings us to the missing stakeholder.
Look at who is actually in the courtroom. We have the regulators. They want power. We have the states. They want tax revenue. We have the platforms. They want profit.
Who is missing?
The American public. You. The learner.
Why does that matter in a legal context?
Because the broader public interest isn't fully represented in a lawsuit between a tech company and a gaming commission. No one is standing in front of the judge arguing for option C just because it might be good for society.
It goes back to the diabetic kid analogy we touched on earlier.
Right. Maybe the best outcome for the public is no sugar. Maybe the best outcome is to not have a casino in every single pocket. Maybe the social costs of gambling addiction outstrip the tax revenue it generates, but that option isn't being litigated by the parties.
Because the states want the money.
Correct. The states are addicted to the tax revenue. They aren't going to argue that gambling is bad. They're just going to argue that they should be the ones selling it.
And the tech companies want the money.
Obviously. So you have a massive fight over the loot, not over whether the looting should happen in the first place.
It is a sobering thought. We always assume that court cases yield the correct result for society, but they really only yield the result that one of the lawyers specifically asked for.
Which is why the false binary is so dangerous. It completely limits our imagination of what the law actually requires. It blinds us to the possibility that maybe, just maybe, the whole thing is built on sand.
So what does this all mean for you listening at home? Let's wrap this up.
We started with a dramatic question. Could this massive industry be wiped out?
And after looking through the lexicon lens, the answer is maybe.
It is a distinct, realistic possibility. The industry feels permanent because of the ads and the sheer amount of money. But it rests on a complicated web of statutes that were written decades before the internet even existed.
If SCOTUS applies that holistic view, looking at preemption, permissibility, and parallelism altogether, the result might not be a win for Kalshi or the states.
It could be a hard reset button on the entire industry. It could be the Supreme Court saying none of this is legal until Congress actually writes a modern law that says it is.
Which would force Congress to actually do its job.
Imagine that.
So here is our final provocative thought for you to chew on as you go about your day. We always assume that technology moves faster than the law, and that the law eventually catches up and validates the technology. But sometimes, the law is a wall, not a road.
And sometimes the wall wins.
Keep your eyes on the Supreme Court docket, because while everyone else is watching the Super Bowl odds, the 9 justices in robes are the ones who will actually decide if the game can even be played.
That is exactly where the future of this economy is being written.
Thanks for joining us for this analysis. We will see you next time.
Take care.